Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hello. Oh, Casey Carey. Starting us off quick. Big squishy hugs right back at you. Thank you so much. Let me... Oh, I don't know what that sound was. But it's never very good when the computer chimes at you. I hope everybody is doing well today. It is time for a dab. I just have to cut my brain off of what I normally say right after that. Anyways, let us get going. I appreciate your patience. Hi, Metal Rules. Hi, Vicky. I appreciate you guys' patience today. I had this video and I forgot that I hadn't put it in the right format. So now we have it in the right format. I would love to hear what you all are doing today. What is your Saturday plan? I'm trying to get this over with because, don't take offense to that, but I have, I want to make wonton soup, like a big batch of wonton soup. Per chance 150 or 200 wontons. That's my goal. And I also want to go to the gym first so that I can like just come home and then cook and clean and do all the things that I've done. So I have to do the gym first. I did go to the gym yesterday after our live. I'm proud of that. A solid hour on the elliptical. Woo! We're going to do it again today. Courtney, you ate an olive with a piece of habanero in it and you're melting. There's this amazing olive tapenade that I tried recently. Oh. Listen, by the way, we are going to have the most amazing December. I've got a few tricks up my sleeve that is going to make this holiday season really fun. For us as a family. So get excited for that come December, mid-December, because my daughter's birthday is in the beginning of December, and so I try not to go ahead and celebrate Christmas until her birthday's cleared. I don't know, I just, some people do like a month countdown to their birthdays. Some people... I don't know who on earth would do that. What kind of fucking narcissist would do that? But, so I'm cognizant. But I guess it just doesn't make me a narcissist that I'm cognizant that she might want to celebrate like that. And so I don't do Christmas until. Anyways. Why is half my shirt disappearing? Oh, there we go. Thank you. Also, last night at the gym, you guys, the gym bros were out in force. They were flirting with the gym gals that were also out in force. My mom, like me being a mom just came forth in me. I don't know why. But I did work out for the full hour, so there's that. Anyways, let's get going with this case. Judge Madrigal, with her El Paso accent, as we've been told that that's where this accent is from. I would believe that, Courtney. I would believe that. Now, I put it in, for the first 20 seconds here, I put it in 1.25, maybe the first minute. But don't worry, she's going to slow down soon enough.
We're now live streaming on YouTube. This is Judge Dulce Madrigal. I'm hearing cases out of Comal County today by Zoom on Friday, November 22nd, 2024. At this time, I will call cause number C 2015-0736B. Present in my virtual courtroom is one of the parents. That would be the custodial parent, Amber Nicole Hale. Ms. Hale, go ahead and announce yourself with your full legal name.
Amber Nicole Hale.
Thank you. Now I need to swear you in. If you'd raise your right hand for me, ma'am. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. For the record, the non-custodial parent, Zachary Richard Hale, is not present. It looks like he has not appeared today. The case was set at 8:30. It's now past 11 o'clock, so I presume we'll be going for it by default, but the state will tell me, or give me a bit of a background in just a moment. Just so that you are aware, ma'am, let me tell you a couple things about my court. One is that I'm an associate judge. I've been appointed to hear cases filed by the Office of the Attorney General. And as an associate judge, we are courts of record. However, we don't have court reporters. We have a digital recorder. So I tell you that to be mindful. And when you're answering questions, make sure all your answers are loud enough for the recorder to pick up and the court to hear. No shaking your head or nodding when answering, and no ahs or ahs. I need more formal yeses and nos. The second part of the recording issues, you heard me announce we were live streaming on YouTube. It is a requirement that the courts are open to the public, and as the publics are required to be open under our Constitution, and that's been true for forever. However, when COVID hit, it stopped everything. Courts had to go to the computer to Zoom court for a minute, and so they set up the live streaming on YouTube as a way for the public to log in and watch courts at work. And so the child support, since COVID has been over, most courts have gone back to their courtrooms. However, the child support courts have been allowed to continue on Zoom. And because of that, that's why we're still live streaming as a way to meet the open courts requirement. So I tell you that to be mindful of it and not blurt out your home address, social security number, cell number, something you would not want out on the internet identifying you. If you say it, it's gone, it's too late, I won't be able to retrieve it. The other part of the YouTube app is that they are recording as well. It's not the official record. It is authorized. However, as soon as I can, after I'm done with my duties in the virtual courtroom, I'll go to the YouTube app and delete any recordings that are out there. They will not be out there indefinitely. The public's only entitled to the live version here going on right now. The last part of the recording issues is do not record. It would be considered a violation of our laws, subject to contempt of court, punishable by fine and or a jail sentence. So that applies to anyone here in the virtual courtroom and anyone outside observing in. So given all that, with all the recording issues, Ms. Hale, do you have any questions or concerns at this time?
No.
And then what was the other part? I've had a long morning already. I just want, are you consenting to go forward on Zoom today?
Yes.
Okay. And just to make you aware, there's a couple of other people here in the courtroom. They are staff of the AG's office or my court coordinator. They are allowed to be here and required to help if they're necessary, but they won't be participating otherwise. Mr. Calvano, if you'll go ahead and announce and give me an opening statement soon.
Yes, Judge. Excellent. Judge, this Corey Calvano for the Attorney General's office. This case was filed as a petition to establish the parent-child relationship and a suit for modification and motion to confirm support arrearages. We're adding a dependent to the case, essentially. This case was filed on February 22nd, 2024. Mr. Zachary Hale was served in this matter on the 22nd day of March 2024 while incarcerated in the Vance unit. Mr. Hale also filed an answer that's file stamped here in Comal County on April 1st, 2024. And this court entered an order on respondent's request to appear on July 15th, 2024. And in that, denied the request to appear in person, did grant any ability to appear by Zoom or by affidavit if possible, if the unit allowed. Mr. Hale has not appeared here today, and so we are asking to move forward on a default.
And as far as you can tell, he didn't file an affidavit to support his story?
He did not, Your Honor.
Okay, well, I think we did all the appropriate things, and from July 15th to now November, we gave plenty of time for all that to happen. And it's now 11:14, so I assume the jail or the facility, TDCJ, is not allowing him to appear. Otherwise, he'd be here.
Then I will ask to move forward by calling a witness, and I think that's the easiest way to get everything on record.
Okay, you may proceed.
Then I'll call Amber Hale. Again, will you state your full name for the court, please, Ms. Hale?
Amber Nicole Hale.
And Ms. Hale, is it true that let me see if I can find it. Sorry. In the final decree of divorce that was entered March 31st, 2017, between you and Zachary Richard Hale, that the child, Jaden Hale, was established, correct?
Yes.
And is it also true that you went for DNA testing with the child Avery Nicole Hale?
Yes.
And if I may share screen, Judge.
Yes, sir.
I'm faster than you are.
How old is she, ma'am?
She's 6 years old.
Okay.
Oh.
Hmm.
Okay. I think it's going to come up now.
Okay.
This has their DNA numbers in it. I don't know if those mean anything, but if there's anything that is personal, I have a feeling it's your DNA sequence. That's the reason I'm covering the screen. Has all 3 of their DNA.
And Judge, it should be on screen now, and the state would request that the court enter as Exhibit A, which will be attached to any order here today, the DNA test report that has the child Avery Hale, with the father listed as Zachary Hale and the mother listed as Amber Hale, and the probability of paternity is listed as 99.99999%. So the father cannot be ruled out. Well, I guess Zachary Hale cannot be ruled out as the father.
Okay, I'll take judicial notice. I will admit the exhibit as State's Exhibit A, which does support the establishment of paternity with the 99+%, and I admitted it as well.
Thank you, Your Honor. So, Ms. Hale, you're asking that the court establish that Zachary Hale is the father of Avery, and that he has a duty to support that child. Can you tell me, well, the last name is going to remain the same, correct?
Yes.
And then as far as the conservatorship is concerned, you're asking that the court order that you be appointed as a sole managing conservator and Zachary Hale as a possessory conservator.
Yes.
Can you tell the court if you know why Mr. Hale is currently incarcerated?
Yes. When Avery was 2 months old, he had accidentally dropped her. But rather than taking her to the ER, he hid it. I'm the one who took her to the ER whenever I noticed something was wrong with her. And when it all came out in the wash, like she had to have emergency brain surgery to get a shunt put in. And it was really bad. And when it all came out in the wash, he tested positive for meth. So at the end, he got convicted for, I believe it was severe negligence that led to a severe injury of a minor child. It was a long title like that. And they gave him years.
I'm sorry, repeat that one more time. I interrupted you. I apologize.
Okay. I believe that his full sentence was severe negligence that led to a severe injury of a minor child.
And you were trying to say he got 8 years, correct?
Correct.
And so his projected release date is August 11th of 2027, according to TDCJ information. Is that correct?
Yes.
But do you know whether or not Mr. Hale has been granted parole?
He has been given parole after, I believe in April, they said they would give 6 months to complete a program and then release him on parole, where I believe he'll be going back to Ohio to live with his mother.
Okay, so in April of 2025, as far as you understand, they'll let him complete a program for 6 months, and then he will be released on parole thereafter.
Yes.
Okay. And so, has there been any contact? I know it's a weird question, but has there been any contact between the child, Avery, and Mr. Hale since he's been incarcerated?
Let's see. They're allowed to have letters and phone calls. The therapist, whenever I took Sherry is not his biological child, but he was with her since the day she was born. I took Sherry and Jaden to therapy after everything went down, and the therapist recommended keeping open lines of communication with him through phone calls and letters.
Okay, so just for the court's knowledge, there is another child born to you named Sherry,
Yes,
and that child is not the biological child of Mr. Hale,
correct.
but Mr. Hale has been in that child's life since essentially the child's birth or close to it. Is that correct?
Yes, he cut her umbilical cord.
Okay. And so when you talk about the older two children, you're talking about that child and your oldest child that has already been established, Jaden.
Yes,
Okay. And then the newest child being Avery, who was born on August 9th of 2018, correct?
yes.
Would you feel comfortable if, or I guess let me restate. Do you have a fear that Mr. Hale would harm Avery in some way, physically or even mentally?
Not at this time. At this
Well,
time, he's completely sober. So as long as he continues to stay sober, it's kind of like a Dr. Jekyll, Mr. Hyde, I guess, because whenever he's sober, he's amazing. And, I thought it was bipolar at first because he was, I'm not sure if he got the official diagnosis, but I know they put him on medicine for bipolar disorder.
okay. And so it's your fear of drug use again, or your fear of what happens, I guess, when Mr. Hale uses drugs, that is, that you're using as the reason for asking for sole managing conservatorship. Is that correct?
Yes.
Okay. When it comes to the child support, you understand that that Mr. Hale doesn't earn any income.
Yes.
And do you know of any way that he can earn income while he's incarcerated?
No.
So there no investments or no rental properties, nothing like that.
No.
And so you understand that when somebody doesn't have any income, that it's requested that child support is set at 0.
Yes.
Additionally, you're asking for child support to be modified. That was ordered on the other child to be set at 0 as well. Is that correct?
Yes.
And that amount was $250 from the previous order. That's how much the monthly child support was, correct?
Yes.
And so the state is asking that these child support amounts be set to 0 as of as of the 22nd day of November, which is today. You're in agreement to that?
Yes.
And we're also asking that medical support, both the modification of the prior order of $125 be set to 0, and there not be any current medical support ordered as of today's date. Do you understand that as well?
Yes.
How are your children covered by health insurance?
I have insurance through my employer.
Okay. Additionally, it is the it is apparent that Mr. Hale is behind in his child support from the previous order in the amount of $26,506.25. Does that sound correct to you?
Yes.
You are asking this court to allow you to release all of that arrearages. Is that true?
Yes.
Can you tell the court why you believe that you don't want those monies that might be ordered that are due to you from a prior order?
I want him to be able to start fresh and really settle with his sobriety, focus on the children. You know, he can start child support once he's out, fresh, clean slate, and he can help support the children whenever, you know, he's finally out on his feet. I want him to show the children that even with his mistake, that he can become something of himself. And so basically, I just want to give him a chance to step forward for our children.
Okay. And so you're asking that all of the back child support be released as of the 21st day of November 2024, correct?
Yes.
Additionally, there's back medical support in the amount of $16,219.63 as of yesterday's date, and you're asking for all that to be released as well. Is that true?
Yes.
And as far as the visitation is concerned, what is it that you're asking be ordered in as a visitation for the child? The child Avery.
So when he's released, he will have to reach out to CPS to start establishing visitation again. I believe they said that they would start with the supervised visitations. I'm not sure how that will work with him in Ohio, but I know that CPS said that they wanted him to reach out to start establishing his visitation rates.
Okay, so because of the nature of his offense, CPS was involved from the beginning with that child. Is that correct?
Yes.
And so, are you asking that this court make no order as to what visitation should be once he gets out?
Yes, because I believe CPS will work with him. I'm not sure how it all goes. I know that CPS will help monitor it and just to keep him, you know, safe. I want to make sure that he's sober and can stay sober upon his release.
Okay.
So just trying to give him the best, you know, I guess the best step forward to get his life on track so that he can become the father he needs to be for the kids.
If this judge, and I certainly understand that, if this judge felt compelled to have some kind of visitation, because without it, it might be considered termination, would you be okay with a supervised visitation at a facility for 1 hour, 1 day a month?
Yes.
And if that facility was in Comal, and he was to bear the cost of that facility, you would be willing to work with him to set that visitation up. Is that correct?
Yes.
And if CPS then ordered more visitation or asked for more visitation or felt more was that he can handle more and your children can handle more, you would be willing to go along with that. Is that true?
Yes. I know he loves children and my children love him, so I'm not opposed to it. I just, like I said, I want to make sure that when he comes out, he stays the sober task.
Okay. And then as far as a non-disclosure is concerned, is it true that in your prior order, you had a non-disclosure?
Yes, they had placed a non-disclosure, they said for mine and Avery's protection. I believe.
And are typically the non-disclosure is carried over by court order. Are you asking that that be removed, or are you okay with the non-disclosure still being continued?
It can be removed. It doesn't matter to me. I've lived in the same house since before the incident, so
Hmm.
Um, but I know it's okay for it to be removed. You living in the same house, but um, is it a request that it be removed, or are you okay with it being continued?
okay, you can remove it. It's a request to remove it.
Okay, it's a request to remove it. Um, so just to get back to the visitation, there is a facility in Comal County in New Braunfels called Kindertime that does supervise visitations. If the court orders it, would that be something that you would be okay with?
Yes.
All right. Is there anything else that you feel that you need to tell the judge that I have not touched on?
Hmm.
Not that I believe. Like I said, most of the reason I want him to start out with 0 and then pick up his responsibilities going out is to kind of minimize the stress and give him the best chance of staying sober. I know that with the 5 years of the sobriety, it's given him a big chance because it's helped reset the pleasure center in the brain and also the chemicals in the brain. So hopefully he'll come out with a much better ability to be who he needs to be.
Okay. I have no further questions for Miss Hale, Judge.
Well, I might hate to burst your bubble, Miss Hale, on the CPS thing, but unless they have an active case, that's when they provide services. I've never heard of a case that, they close the case out because it's resolved. He's not a danger. He's in prison. You did the right things. You had the child. But for them to just say, okay, we'll help you, I just don't see it. They're already under, staffed and have way too many cases. So I think the better route to go is to put something in writing and use a facility, and then the visitation order, and we'll say that anything y'all can agree to is allowed, but if there's no agreement, then this is the fallback position. So if in your good judgment, there's somebody you can pick or yourself to supervise, and I hesitate to even recommend yourself being in it unless you're absolutely sure you're not in any danger, then you can do something along those lines on your own. If you don't think the facility, he can make it there, or let's say you take a trip to wherever he is and you want to have him see the children, any number of things you can do, or he comes down for a holiday and you let him see whatever y'all can agree to, you can do. And if you can't, well, then you're safe in relying on this provision that, well, this is what was ordered. I don't agree with anything else yet. Let's start here. Let's start slow and build up. If you want to do something like that, that's more doable than knocking on CPS door and saying, "Here we are, help us," and there's no active file. Because they usually work cases that are open in their case files.
Okay.
Got it? So, okay, then, and I heard the projected date is, what did you say, next year, maybe?
Um,
Yeah,
possibly,
in a couple years.
yeah, depending if that's when he completes the program. I'm not sure what the program is, but it's a 6-month program they want him to complete before the release.
Yeah, okay. Then, okay, is there anything else you think you need to state on the record that you haven't already been asked?
No.
Okay. Any closing, Mr. Cullen?
Just a couple more questions for Miss Hale, if
Sure.
I may, Judge. Miss Hale, if the judge does order one day a week or one day a month, I guess, what day would work best for you for that visitation?
Um,
A Saturday or a Sunday?
yeah, Saturday would probably be best.
Okay. And is there a time that would work best? 10 a.m., 2 p.m.?
12 o'clock.
12 noon?
Yes.
Okay. And is there a preferred week? If it's only one day a month, the third week of the month or the third Saturday of the month, does that sound reasonable?
That's fine.
Okay.
She is so reasonable, almost too reasonable. She's eliminated what, $40,000 of his debt, given him, I don't know. I don't know. The first time I listened to this part of this, I was like, wow, she's such a big person. She really just cares about her kids and doing the best for them. And then part of me is like, is she just deeply still in love with this guy? Like, what is going on here that she's relieving all this debt? Like, I don't know. And remember, she had a different baby in the middle. She has his baby, another man's baby, who he was there and cut the umbilical cord for, and then his baby.
Then no further questions on the visitation judge, barring your honor's determination what the schedule should be.
Yeah, well, yes, I would go along with that. That's not a problem. Well, it should say something that all costs to be borne by Mr. Hale, correct? So he
Correct,
can pay
Judge.
for all of it. You didn't want to pay for half of it, Ms. Hale, I presume.
Yes.
Okay, cost of the program, to be borne by Mr. Hale.
Thank you, Your Honor.
And then I think there's some minor provision we can put in there that you're required to cooperate with, you know, setting up the account and taking the child there and what have you once it's, if he decides to go that route or y'all decide to go that route. You just to cooperate with the policies and the procedures of the program.
Okay.
Okay, I think that's all we need. I guess any notice you would have is that him setting it up or letting you know he's gonna go set it up, and then you also have to do your own kind of intake with them, and then they tell you when to bring the child. We put the specific amounts for the facility's sake, but chances are if they have a lot of cases and they can't provide you that particular Saturday, that particular time, they can tweak it, and you can agree with that based on their schedules, I presume.
Thank you.
Okay. So now you need a closing, Mr. Colonel?
Yes, Judge. The state is asking that the child, Avery, the parentage be established in Richard Hale as the father of that child based off the DNA order, and that he has a duty to support that child, and that the parties be named conservators, but Miss Amber Nicole Hale as a managing conservator and Zachary as a possessory conservator. Miss Hale is asking that that the child support all be released and take a judgment of 0 as of yesterday's date, and the same with the medical support as of yesterday's date, and that no child support be set for the support of Avery, and that the child support for Jaden be set to 0 as of today's date as well, and that she be the person ordered to continue to carry the health insurance through her employer. And she is not asking for a non-disclosure, and actually is requested the court lift the prior non-disclosure. And I believe that's everything that Ms. Hale is asking for. The state is asking that Mr. Hale, Zachary Hale, be the person ordered to burden the costs of the court. And that is the extent of the order at this point.
Usually when they're incarcerated, don't have income and aren't gonna get out for a while, I either waive it or I have to set a future date where he can pay it, but you have a preference, Mr. Colvin?
The state has no preference, Judge?
I'm gonna go ahead and waive them. They're too hard to collect 2 or 3 years from now. Okay, so if I understood right, on the current child support, it's setting support for Avery and modifying support for Jaden. but it's 0 months starting. You wanted to use the November 22nd date, is that what I hear?
Since we are zeroing out the retroactive supports as of yesterday, we would like to use those today's date,
Okay.
correct, Judge?
That would be fine. And then stair step for the child Avery. For 2 it's 0, for 1 it's still 0. I assume you have to put that in the order.
That's correct, Judge.
And then medical support, usually leave it as 1 for both, 0 a month. Also starting November 22nd. Mother to carry the insurance. I will lift the non-disclosure as requested with mother's consent. And then court costs waived. And I skipped the first part. Yes, I'll approve the paternity establishment based on the DNA results for Avery. And you said you'd attach the report to the order. Please do that.
Yes, Your Honor.
And then you did say you didn't want any name changes, so they both continue with the surname Hale. The children, and the joint managing conservatorship is rebutted. I will appoint mom as the sole managing conservator, father of the possessory conservator. Okay, there's rights and duties that come under that order that they're set out by the family code, and if we don't want something, we need to affirmatively delete it. But you're not aware of that laundry list. But the one I'm always concerned about is, do you want him to go to be able to attend school activities and lunches at the school with the child, those kinds of things? I assume it'd be in a supervised setting if he's in a cafeteria. And then you get to put that he doesn't get to pick up the child with the
Okay.
office. I'm not talking about that, but it's the attending school activities and having lunch with the child. I think that those are specific. Do
Okay,
you-
I'm fine with that as long as he can't pick up the children.
Well, then you'd have to just put that on the intake or with the office, let them know child can't be released to him.
Okay,
Okay. That's the way they usually handle that. Okay, and that's the only one I could think of at this time, Mr. Calvano, that would specifically put the child in Mr. Hale's possession if he gets to go to the school. So we're not removing it. She's okay with it.
The rest of them, yes, Judge,
The
it
rest
looks
of them are
like
fine,
they're
yeah.
about information. So,
Okay. Yes, and I will order specific visitation in case nobody else gets involved and helps you. But if that avenue is available, please take it. But I just don't see it happening, especially for an out-of-state person. I assume he'll be there for a while in terms of his parole or probation or what have you, would have him there under his mother's supervision for who knows how long. Is that what you're understanding, Ms. Hale?
I'm not sure. From what I understood, they were thinking about having him go and live with his mother. Like if he doesn't go there, then he would either go to, I think it's Houston or Dallas to
Okay.
those homes.
And where does his mother live? Did I hear it was out of state or was it somewhere else?
Ohio, Dayton,
It is
Ohio.
Ohio. Okay. Okay, then I think what we've done here would take care of what we can do here, which is some limited issues. And then y'all are still parents. Y'all still get to, if you want to talk to him. Would you be talking in person or like by cell phone or text? Or there's an app that we can put in the order if you want to communicate by. It's a free app where it allows you to communicate, says share documents, and then it keeps a record if you ever need it for court if he gets ugly or threatening or anything. That's something you could probably use. I wouldn't expect it, however, you never know. So would you want to use an app that's free to you all for communication, Ms. Hale, or are you okay without it?
I'm okay without it, but thank you.
Okay, well, I just want to make that available if you even know about it, but if you don't want it, I'm not forcing it on you. Okay, then I'll approve all the requests and by default against Mr. Hale, and the state's gonna draft the orders. They have a week to turn it in, so that what they do is they try to draft it hopefully by the end of the day. If not, it would be Monday. Oh, next week's a major holiday where most of us are not working half the week. So do you need more time, Mr. Calvano, to get our signature back?
we should have it out today, Judge.
Okay, do you think you could get it signed by today, tomorrow, and pretty much today or tomorrow, Ms. Hale?
Yeah,
Y'all don't work on Wednesday, do you, sir? Or maybe not even tomorrow, Mr. Cullen?
No, we work on Monday, Judge.
Just
And
today?
then,
or
well,
on Monday?
there will be some people working on Tuesday, Wednesday, Judge.
Okay, well,
I'll work.
If they send it today, I'll ask you to review it as quick as possible because it comes to me electronically so that I will be open Monday, so I can still get it and sign it. If not, it'll be another week. I hesitate to make it so short, but on the other hand, this is a pretty easy order. And if you can get it done, it gets in the file quicker. If I see it, I'll sign it. If it's not there, I won't sign it. I'll wait till it comes in. And I'll give you another week for that, Mr. Calvano, if you need it.
Okay, thanks, Judge.
But do check your email starting this afternoon. Anything from Texas Office of the Attorney General is this proposed order that needs your review and sign. If you have a problem, a question, be mindful that they may not be there most of next week, but you can call and ask or try to get anything corrected if necessary. Okay.
Okay, thank you.
Is that
Any
'cause of
questions?
Thanksgiving?
How does the child support start up again whenever he's released? Do I have to then request something?
You have to request that they file a modification. And if you know the date's coming and, I'd try earlier rather than later so that they need some lead time to get the file ready and the pleading on file and what have you and get a court date and all that. I don't know what their timelines are. I guess you can call and ask them what you should do, but yes, you'd have to probably ask them for it. You might be more aware of his release date and be on top of that than they could possibly be with millions of cases, well, thousands of cases. So yes, if you don't file something and it takes a while, then you're kind of out of child support for that period of time because it.
Oh, Miss Donna Orlando Chiquita gifting 5 memberships, Streamlabs on it, Donna on it. Look at those gifts. So thankful. It's Thanksgiving coming up, right? That's what they're talking about. Hi. I hope you guys have a great week coming up. I've got one more case of this judge that we'll listen to today before I go to the gym to torture myself so I can eat cheese later. Oh, so much cheese. There we go. There it is. And yeah, happy birthday to your kid.
We're now live streaming on YouTube. This is
Okay,
just
Judge.
Dulce Madrigal. I'm hearing cases out of
Judge.
Comal County today on Friday, November 22nd, 2024 by Zoom. I will now call cause number C 2013-0265C. Present in my virtual courtroom is one of the parents, the custodial parent, Melissa Jasmine Demps. Ms. Demps, go ahead and identify yourself with your full legal name, ma'am.
Melissa Jasmine Demps.
Thank you. The other parent is the non-custodial parent, Michael Allen Woods Jr. And it looks like he is not present. This case was set at 8:30. It's now after 10 o'clock. And it looks like he's not appearing and we'll be going forward without him. First of all, I need to tell you a few things about my court before we go forward, Ms. Demps. One is that I'm an associate judge. I've been appointed to this position. I hear cases filed only by the Office of the Attorney General or Child Support Unit. And as an associate judge for a child support court, we are courts of record, but we do not have court reporters available to us. We have a digital recorder. So be mindful of that. I'll ask you to make all your answers verbal when you're answering questions. Make sure you're talking loud enough for the recorder to pick up in the court to hear. No shaking your head or nodding. That is not recorded. No ahas or ahs. I need more formal yeses and nos. The second part of the recording issues is that you heard me announce we were live streaming on YouTube. It is required that the courts are open to the public, and that was set up a long time ago with our Constitution. The public is entitled to watch their courts at work, and we're obligated to be open. So they set it up for during COVID when everybody had to shut down.
I have been tracking my calories religiously. The problem is I want to eat about 3,000 calories a day, which means I would have to burn like 4,000 calories a day. So yeah, I'm trying to burn 3,000 calories a day and eat 2,000-ish. But I'm often over. And it's because I drink shit like this. I drink a lot of my calories and I enjoy it. But yeah, I know the premise of weight loss. But here's the thing. I've been going to the gym now religiously for almost for half of September, October, November, so 2.5 months. And, well, we'll see.
and we weren't in our courtrooms, they set up the live streaming on YouTube as a way for the public to log in and observe proceedings still, as is our right and is our obligation. So the live stream on YouTube, I tell you that so that you're mindful and you don't blurt out your home address, your social security number, something on your cell number, something you wouldn't want out on the internet. When we're done with the live proceeding here, which is what the public is entitled to, there's a recording being made and authorized to be made on YouTube. However, I'll be deleting that as quick as I can, so it won't be out there indefinitely. The last part of the recording issues is do not record. It would be considered a violation of our laws, subject to contempt of court, punishable by fine and/or a jail sentence. That applies to anyone here in the courtroom or anyone outside observing in. So, having heard all of that on the recording issues, Ms. Demps, do you have any questions or concerns?
No.
Okay, and do you agree to go forward on Zoom today?
Yes.
I heard you say yes, barely, but I'm not sure the recorder picked up.
Yes.
Thank you, ma'am. Then, and just so you know, there's other people here in my virtual courtroom. They happen to be staff of the Attorney General's office or my court coordinator that we might need as far as help maybe, but they're not participating in your hearing. So, hold on a minute. Can somebody allow the person in the waiting room to come in, co-host them, and put them in the break room? Thank you. Ms. Coates, if you'd go ahead and announce.
Judge, only you can do the co-hosting. Make somebody a co-host when you're the
Okay,
host.
well,
I want
well, maybe not. Okay, let's just go on and do this real quick.
All right, Judge Deandra Coates for the Attorney General's office. We're doing a confirmation of arrears and modification. Honor remembers this case from last time. Miss Demps wanted time to get an attorney to see if Mr. Woods had any income or assets because he was incarcerated, and so she didn't want to move forward at the last setting. And so, but she is willing now with no attorney, and then just accepting that we will set child support at 0, medical at 0. She'll continue the children on government insurance, and we'll be taking judgments at the end of April 30th, in the amount of $34,367.22 to be paid back at $22 a month, starting December 1st. Medical support judgment of $10,040.
Hold on, $33,000. Let me just do a little math here. 33, let's just round down to 33 even for the benefit. Divided by $22 a month. That's 1,500 months. 1,500 months is 125 years to pay back that money. And that's not even, what? What?
$4.42 to be set at $100 a month starting December 1st. And just for the court's refresher, on April 26th, Mr. Woods was not served. However, he did appear on April 26th, which was our first setting, Your Honor. Again, we have that right here, just for the safety of covering ourselves. He
So
was
that's
here on
where
April
he
26th.
Where he actually appeared, because that was from April and it was set to June. So there's some subsequent resets, I guess.
Yes.
Okay.
And then eventually he got arrested, Your Honor, and is in TDCJ. And so we did send notice for this hearing to TDCJ as well. So I'm going to share the screen. For the Texas Department of Criminal Justice, I am showing the screen for a Michael Allen Woods. And he is in the Lynchner facility. He has a maximum date of April 8th, 2028. He has a projected release date of March 14th, 2026. He was up for parole last month on October 25th, 2024. However, he did not make parole.
Okay. And what else do you have?
And just scrolling down just to show you his offense, Your Honor. It looks like the one that he's currently serving is for unlawful exposure. SBI, I'm not sure what that one stands for. and assault, violence, family violence impending, I'm assuming. That's what the F and the violence is. And he got 4 years for both of those counts. Actually, there's another count there as well. The violence protective order. So he violated a protective order. So he's got sentenced to 12 years. Wait, right? Yeah. 12 years.
Okay. Thank you. And I'll take judicial notice the Texas inmate details that you just referred to on screen share. And also that he signed and made an appearance by appearing in court on the reset with the reset order signature on April 26, 2024. So you'll go forward by default.
Yes. All right, Miss Stamps. Did you hear what I explained to the judge that we have to set current obligations, the child support and medical support to zero?
Yeah.
Okay, and do you still have an issue with, are you still objecting to us setting it to zero?
At this point, no, I just need to get to work. I've been fighting this for 17 years. There's been no enforcement, so this is not, nothing's going to change. He's not going to get out of prison anytime soon. So I just need to stop going to court for no changes so I
And
can
you're-
keep my job.
How old is your child or children now?
My oldest one will be 18 December 1st. Our youngest one will be 12 on Christmas Eve.
Thank you.
they're turning
18
in
on December 1st and 12 on Christmas Eve.
Is the 18-year-old still in high school?
Yes.
Okay. And he's expected to graduate in June of 2025?
Yes.
Okay. And then they're covered how on health insurance?
They are on Champs VA.
Yay, thank you so much. Oh, you're so sweet. Thank you, thank you, thank you, NPC. What a lovely just because. And guess what? You can look at anything donated this month is like a Christmas gift because I will get it right before Christmas from YouTube Daddy.
We have not qualified for Medicaid in a while.
Okay, so you're carrying it through a different source. Okay. This is not through your work?
No, I am self-employed.
Okay. All right. And then I asked the judge to take judgments as of April 30th, and I had suggested a repayment for that child support to be at $222 a month starting December 1st. Do you have any issue with that amount?
222, not 22. We got to redo the math. Because remember, we did this at 22. So we got to redo the math here. So it's $33,000 divided by 222. 148 months divided by 12 will tell us the years. 12 years and 43/111th will get us to him being charged. Or dealt with, I guess. 12.387 years. It feels like 125 years as well, doesn't it?
Or do you believe it should be higher once he's released? This is what he'll be paying back once he's released and obtains a job.
I don't know, honestly.
Well, is it an issue if we set it at $222?
I mean, I think when he gets a job, it should be reevaluated, but it's been set higher and lower. He's never made the payment. So it doesn't really matter, honestly.
Okay. And then the same with the medical support being set at $100?
Sure. Yes.
Okay. All right. And then those charges of family violence and a violation of a protected order, was that against you?
No, he got family violence. He had gotten a family violence case, I believe, when we were getting divorced from another family member. Therefore, he has very restricted visitation with the children. I don't know who this one is.
Do you have any
He,
safety concerns?
no, I have not physically seen him nor have the kids in many years.
All right. And does he have your phone number or or address?
He's got my phone number and email along with our oldest son's phone number, but he makes no contact.
Okay, so you're not afraid he's gonna harass or threaten you once he finds out what we set the amounts to.
No, I think he'll be very happy that it was set to $0 or 200. So no, I don't think he'll come at me for that.
Okay. So we're taking judgments for what he owes. Now, if he gets out before your youngest graduates, you understand you can ask for a modification then.
Yes, however, he's self-employed, so that's been the issue the past years.
Okay. So I just wanted to make sure that you don't have any safety concerns then, just, knowing that.
Nope, I do not.
Okay. Anything else the judge needs to know at this time?
Nope.
Your Honor, I have no further questions and ask that you grant the judgments and the zero obligation and given, oh, Your Honor, I do apologize. Let me show you the financial activity report because this is what I would like to bring up as the last.
Sure, attach it to the order as well, but I'll look at it now on screen here, screen share.
Okay, so we would ask that this be entered in as Exhibit A. Ms. Demps would have seen this or gotten a copy. Ms. Demps, you've seen this or seen something similar to it?
Yes.
Okay.
Okay, can you scroll over to the right so I can see the date and the page numbers? There you go. It is printed today.
Yes, Judge, and there's 6 pages.
Thank you. You'll go to the last page for the numbers you're seeking. As of April 30th, you said.
Yes, right here, Judge.
Are you going so far back?
Your Honor, I know that you
Service, okay.
yeah, due to the data service, so they were both here on 4/26, so that's the latest.
Okay, so then you want to start the modification May 1st?
Yes.
Okay. And so April 30th, we look across on the financial activity report, trying to thank you for increasing the text size. Let's see, $34,367.22. And for child support, and $10,044.42 for medical support. The pay record does support the judgments requested as of April 30th, so thank you for that, and do attach it to the order.
Yeah. And lastly, we ask that he pay the court cost at least 1 year from the date once he's released from.
Well, if you put that in there, yeah, but not 1 year from today, it won't be out.
No, we'll put 1 year from release of incarceration.
Okay. And I didn't say it out loud. You asked me to admit States Exhibit A, the financial record, and I will admit it. Ms. Demps, I know you're not happy or you're dissatisfied or what have you, but can you prove that he has any income while he's incarcerated?
No, and I'm dissatisfied with the whole system for the past 17 years. I mean, this has been going on for a very long time.
You didn't have to
So
repeat it. I sympathize. However, there's certain laws that we're required to do, and there's certain things.
I understand that, but even when he was on parole, this should have been part of his obligation to pay that, or it was a violation of parole. I mean, it's been going on for 17 years. Nothing's going to change. He's not going to pay. It doesn't matter what the amount's set to, you know, so I don't really have much to say. I don't want to hire a lawyer.
Okay.
I've already
I would
wasted
highly
too much
suggest
time.
that when you know he gets out or close to getting out, that you apply with the state for the modification, so it's no longer zero for your younger child, and we can reinstate at least the child support. Maybe one day he'll hit an inheritance. Maybe one day he'll have some kind of PI settlement. Maybe one day, I don't know. If you know of any properties he has or anything in his name, you can have the AG actually put liens on it.
I've already tried that in the past,
Right.
ma'am.
Okay.
It doesn't work. I need to get to work. I'm so sorry. I can't lose my job.
Okay, if there's nothing further, I will grant the default in its entirety against Mr. Wood by default, and I won't repeat it and waste Ms. Demp's time. So, Ms. Coates, I have approved everything you requested. Anything else?
Thank you.
Then that'll conclude this hearing, ma'am. You're excused.
Thank you.
Good luck.
Nice nails. What job does she have?
Ms. Demps is out of the virtual courtroom. That concludes this hearing. I'll stop my
That brings us to a perfect hour that we spent together, a power hour on a Saturday. Thank you so much for being here with me. I need to go change my laundry, put my workout clothes in the dryer, get ready, go to the gym, and then excited for what we have tomorrow. A very interesting members only it will be. Thanks so much for being here. I really appreciate each and every one of you. Remember that I love you and I'm proud of you, and I will see you in the next video. Bye.
Ways down and ready to ride.